Hey, Zach.
Hey, Ron.
So you got some Chapter 13 questions for me?
I do.
Okay.
So in a basic sense, what is a Chapter 13 bankruptcy?
Alrighty. A Chapter 13 bankruptcy, as opposed to a Chapter 7 bankruptcy, one of the main differences is that in a 13 you're going to be making a series of payments, as opposed to in a 7 you're not going to be making a series of payments. In a Chapter 13, you basically work with your attorney and you pitch to the trustee a payment plan where you're going to be making a series of payments. What those payments are is that you take your income less your expenses and then you find out what your net is. That shows what you have left over at the end of every month. That net number is then sprayed and sprinkled to creditors that you have, and it's done in a manner that the check goes to the trustee and the trustee issues individual checks to make payments towards your creditors. And those payments could be payment in full, which is called a 100% payment plan, or it could be a partial payment. So for example, let's suppose that you have an extra $500 left over at the end of every month, and even if you paid $500 to the trustee, that wouldn't come close to covering all of the debts that you have. You could still do a less than 100% payment plan where you just surrender that $500 every month and the trustee makes payments. At the end of the day, you ultimately don't pay back all the creditors everything that you owe them, but at least they get a chunk of what's owed to them over the duration of 5 years. So that's one of the main distinctions between a Chapter 13 bankruptcy and a 7 bankruptcy.
So can I do a 5-year plan to lower my monthly payments?
Yes, there are certain criteria as to whether you could do a 5-year or you could do a 3-year. For the most part, most people can do a 5-year, and most people want to strive for a 5-year because if you take the debt and then you divide it out by 60 months as opposed to 36 months, obviously that's lower payment every month, and people going into bankruptcy are looking for a lower payment for some relief. So yes, for the most part, you would be able to get either a 3-year or a 5-year, but most people qualify for 5 years.
Okay. So when will the creditors stop calling me?
Well, as soon as a bankruptcy petition is filed with the court, which is filed electronically through the computers, the notice gets sent out from the bankruptcy court to the creditors that were listed in the petition, and usually it's within 72 hours those notices go out, and then it goes out by mail so that the creditor gets the notice in the mail. And what they're supposed to do when a creditor receives it is they're supposed to discontinue any types of collection activity that they're doing with you, whether that be they themselves, or whether they've gone to a collection agency, or whether they've gone to an attorney. Usually what happens is when someone comes in and they have a debt, we'll ask them, we'll say, do you have debt to an individual creditor as well as a collection agency and or a law firm? And if I have multiple addresses, we send the notice out to all of the above, because if we just put the underlying creditor and the notice goes to the creditor, we can't trust that they're going to go and tell the collection agency. We can't trust that they're going to go and tell the law firm, and then the law firm might keep knocking on the door, might even go to the point where they file a summons and a complaint, which they will do because they don't know.
Right.
So then what's supposed to happen is once the creditors get notice, they're supposed to back off. But as you can see, they don't always get the notice. It's nothing to panic about if we had a wrong address, or if it didn't get to the collection agency because we didn't know about it. After the bankruptcy is filed, the debtor contacts our office, lets us know what's going on, and then we make the communication to make sure that the right notice goes out.
Okay. So how do I qualify for this Chapter 13 bankruptcy?
Well, the way we usually do it is we look to see if someone qualifies for a 7, and if they don't qualify for a 7, then we look to see if 13 makes sense for them. There's something that's called a means test that you have to pass in a Chapter 7, which has a lot to do with how much income you make and what your expenses are. But probably the most generic way to explain it is that at the end of the month, if you have some income left over, you're not in Chapter 7 territory, because you have money to pay back some money over time to some of your creditors. So one of the initial criteria is, after we do your numbers and take your income minus your expenses, is there a plus or a minus? If there's a plus, then we're probably talking about Chapter 13 territory. There are some circumstances where people don't qualify for a 7 or a 13. There are certain amounts of unsecured versus secured debt that keeps you contained in a 13. And for the very small percentage of the population that might not meet into that criteria, they can actually file a personal Chapter 11, which most people recognize that as something for businesses, but there is a such thing as a personal Chapter 11. We won't go into that because it's pretty rare.
Right. So you mentioned secured and unsecured debt. What are the differences between those?
Well, if you own a house and you took out a loan against the house, the loan is secured against the house, meaning it doesn't matter what you do, the
Mhm.
lender's allowed to foreclose on that house and,
Right.
and get their money if you disappear. An unsecured debt, for example, a credit card, the credit card's not secured against anything. You signed your name and said, I owe you the money. If you stop making the payment, that IOU becomes negligible, so the creditor now doesn't have a house that they could go after. In fact, if the creditor wanted to sue you outside of bankruptcy, if you weren't filing a bankruptcy, if the creditor wanted to sue you, they would have to get a judgment first before they could try to attach that judgment in a manner that would put a lien against your house. And then they would be converting it towards something that's secured. For example, let's say you had a $50,000 credit card debt, you didn't pay it, they got a judgment, they secured the judgment in the county that you live in, and there it sits. If you own real estate in that county, that judgment could attach as a lien towards your real estate. So when you go to sell your house down the road, that $50,000 clocks at 9% interest, because that's the statutory interest rate, 9%, and it clocks and clocks and clocks. Then when you go sell the house, you got a rude awakening because that debt's sitting there waiting for you. In a bankruptcy, it's important that you explain to the attorney that all the debts that might be out there and prior judgments that are out there, so that they could do things to help get you relief from that sort of thing.
Okay. So what are some of the advantages to Chapter 13?
Well, sometimes let's suppose that you're significantly behind in a series of payments for your house. Let's say you're 12 months behind on making your mortgage payment, and that's a big nut. And you don't have that kind of money right now to satisfy the lender, and the lender is calling you every day. They're calling you on Sunday. They're calling you on Father's Day, and you got all these problems, and plus you owe credit cards on top of it. There's no magic bag that you're going to reach into and pull out the money and solve the problem.
Mm-hmm.
So, where Chapter 13 could become helpful, and an advantage of Chapter 13 would be it allows you to take that arrearage, which say is $30,000. And you could take that and you could divide that out over the 60 months and force the bank, through the power of the bankruptcy court, to take that payment to catch up for the deficiency. So that would be an example of an advantage of a bankruptcy.
All right. So what are some of the disadvantages then?
Some disadvantages of a 13 is that, where are you going to be in 3 years? If we do a 5-year plan, that means you're married to a payment plan with the trustee for the next 5 years. And if you lose the job, if your hours get cut, if you're married and your spouse loses the job, or their hours gets cut, or a separation or a divorce or some kind of illness or some kind of so many things can screw up in life in the next 5 years that might derail you from your payment plan. And the trustees, for the most part, are unforgiving. If you don't make payments to the payment plan, they'll boot you out of the bankruptcy. And then you either lose the bankruptcy or you have to convert to a Chapter 7 bankruptcy. So these are things that could go wrong because nobody has a crystal ball to predict what's going to happen in the next 5 years. So that's one disadvantage of dealing with the Chapter 13. Another thing too is that the tax returns. Let's suppose you get a tax refund every year. The trustees are allowed to take any tax return money that you get and absorb that into the Chapter 13 bankruptcy just like the payments that you would be making every month. They would absorb that money into it. So some people have historically used their tax returns as a forced savings, and that would go to the trustees. So that's another disadvantage. There's other disadvantages too, but those are two big ones.
All right. So if someone were going through a foreclosure, would you recommend this type of bankruptcy?
Well, a foreclosure, yes, I would, because in many instances a foreclosure could be a problem that is solved with a 13 using something similar to what we talked about before. The foreclosure is due to an arrearage. Typically, a foreclosure will start after 4 months of missing payments or more. Rarely do they start earlier than that. That's kind of like the magic number. It seems with lenders. So after the 4-month mark, if they start a foreclosure process, it's because you have a chunk of money that you owe as an arrearage. And if you don't have that chunk of money to work things out with the bank, or if they're not working things out with you, you can use the Chapter 13 as a way of forcing the foreclosure to stop. Because in a bankruptcy, when you apply for the bankruptcy and you file your petition, think of it as like this force field comes up. It's called the automatic stay. It's a protective bubble where all these things that might be going on in state court and Supreme Court foreclosure actions, even district court credit card cases, you know, they're firing at you and they can't get through the bubble because for the period of time you're in bankruptcy, there's a certain way things have to occur. So the foreclosure grinds to a halt at that particular moment, and that gives you an opportunity now to work with your attorney and to pitch something to the trustee and then get it approved through the judge in the bankruptcy court to say to the lender, listen, this is what we're going to do. And if it makes sense and it shows how you're going to deal with that arrearage over a 60-month payment plan, the lender's not going to have any choice, and you're going to be able to force that upon them, and then it becomes a win-win for them because they're getting something in terms of dealing with the arrearage, and for you it puts it in a financially manageable manner that's been approved by the parties.
All right. Well, thanks for clearing that up.
No problem.
Thanks a lot, Ron.
Talk to